Mr. Haas, are you able to hear me okay?
Yes, Your Honor.
On the record in People versus Joey Michael Haas, this is file number 246776, 6779, and 6780. The record should reflect Mr. Haas is present today by video from the Otsego County Jail. If I could have counsel put your appearances on.
For the record, Your Honor, Michael on behalf of People.
Thank you, Your Honor. Richard Trush appearing on behalf of Mr. Haas.
All right, this is set for final status conference in these files today. We do have a trial date coming up here later this month. Mr. Trush, how does the defense want to proceed?
Thank you, Your Honor. So primarily my conversations on this file have been with Ms. Brooker. I do think we have an agreement. However, the agreement that we reached does contemplate a sentencing agreement. I sent a memo to the court outlining what it is and why I think it's appropriate, but given the circumstances, I don't know if the court got it.
I didn't.
I have a copy of it for the court, or I can just orally go through why I think the agreement makes sense.
That's fine. Yeah, you just want to put it on.
And Your Honor, for the record, our office did receive a copy of it, so I'm aware of the contents.
Okay.
So the proposed agreement would be that Mr. Haas would admit the aggravated stalking as well as a single count of UDAA as a habitual second. The proposed sentence agreement would be a sentence within the guidelines range. The basic reasons why we came to this, there's not really any aggravating factors here that aren't accounted for in the guidelines, which is to say they're nonviolent offenses here. The property was largely returned undamaged. There is some restitution sought for some missing property, but admittedly, I haven't got all the information on that yet. I don't expect it to be an issue. But what I would categorize as probably the largest arguments that the court may find to not be within the guidelines would be the prior history, which is accounted for in the prior record variables. And then again, the fact that we have multiple incidents occurring here, multiple crimes within a short period, which again is accounted for within the variables between 12 and 13, as well as PRV 7. So I don't think there's any aggravating factors that should cause the court to exceed.
Mr. Roloff?
That's correct, Judge. I would indicate that as part of the agreement, according to Ms. Brooker's notes, restitution is $490, but there could be some additions to that. But that would be the minimum amount, and that's inclusive of the agreement.
Okay, and then the people, are we treating this as kind of a Killebrew agreement?
That's exactly as I understand how the court would treat it. So that way, if the court indicated it was not inclined to follow that agreement, then Mr. Haas would be able to withdraw his plea, and in fact, we could proceed to trial on all charges.
Okay. All right, Mr. Haas, were you able to hear what the lawyers have said?
Yes, Your Honor.
Okay, so these cases are a little different than normal cases that I have before me for a plea, where I don't really have a lot of information about the underlying facts of the allegations. In this case, because of the PPO proceedings, I'm more familiar with the facts that underlie these charges than I typically would be. And based on that knowledge, along with what the lawyers have had to say here, I don't think I'm going to have a problem going along with the sentencing agreement that the lawyers have indicated. In other words, I don't think there's anything I'm going to learn through the PSI that would change, fundamentally my understanding of the facts here. So I'm saying that, Mr. Haas, because I want you to understand that if you agree to enter into a plea here today, I'm not likely to go outside the sentencing agreement. If I did, you would have a chance to withdraw your plea and you would regain your rights to trial. But I think that's unlikely to happen, and I think the court's likely to go with the sentencing agreement based on my knowledge of your case. Do you have any questions about that?
No, Your Honor.
Okay. That being said, Mr. Haas, did you want to accept that plea agreement and enter a plea here today?
Yes, Your Honor.
Okay. And Mr. Trush, can you tell me, just state that for the record again?
Yes, Your Honor. So he would be admitting to the aggravated stalking as well as a single count of UDAA. Both of those would be as a habitual second. And those will actually be no contest pleas. And when he was apprehended, he was taken to the hospital for medical treatment and reported at that time and consistently since then that he had no memory of what had occurred the prior evening.
And Your Honor, for the record, is Mr. Haas was apparently found in a field under rather cold conditions, that's suffering hypothermia. The people have no objection to the court taking a no contest plea on that basis. I believe, and defense counsel has shown me copies of the report and an affidavit of probable cause I'm familiar with since I filled it out. We have no objection to the court considering that as a factual basis. I just merely asked the defense to indicate which of the two UDAA files Mr. Haas will be entering a no contest plea to.
It would be the 2013 Kia Optima, and that's because that's where I understand the restitution stems from.
Okay.
Very good, Judge.
May I approach? Yes. So this would be the basis for the UDAA, and this would be the basis for ag stocking.
Okay.
Can you tell me the case number?
I'm gonna do that.
Okay.
here in just a
All right,
second.
thank you.
So, okay, so what we have is a plea to the one count complaint in file number 246776, which is the unlawful driving away relating to the Kia Optima as a habitual second. And a plea to the one count information in file 246780, aggravated stalking as a habitual second. And both those pleas, no contest. So Mr. Haas, can you raise your right hand, please? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You can lower your hand. Mr. Haas, you understand that the maximum possible penalty you could face for aggravated stalking is up to 5 years and or a $10,000, I'm sorry, as a habitual second, would be up to 7.5 years. Do you understand that?
Yes, Your Honor.
And that the unlawful driving away of a motor vehicle as a habitual second carries with it the same maximum possible penalty of up to 7.5 years. Do you understand that?
Yes, Your Honor.
Counselor, are there any consecutive sentencing sanctions, either discretionary or mandatory, that would apply in this case?
So yes, there is at least potentially a parole violation.
He was on parole at the time of the alleged offenses, yes, Judge.
Okay. And Mr. Haas, you understand that because you were on parole, that any sentence that you would serve in this case may be consecutive, in other words, back to back to any violation sentence you may receive regarding your parole?
Yes, my lawyer informed me of that.
Okay. And then also jail credit?
So the time he's sitting, if they don't have a detainer on him, would count towards the file. I think if they don't have a detainer, he would get credit up until they start the proceedings, I believe.
There's a detainer on him, so
Okay.
he will not be in jail.
Okay.
And you're right, I did just want to clarify that the court said he may not, or it may be consecutive. I think by statute it's mandatory consecutive for a parole violation.
And that's correct, Judge. I would agree with that statement.
Okay. All right. Thank you. Mr. Haas, did you have any questions about those issues?
No, Your Honor.
Okay. All right. And so with all of that in mind, Mr. Haas, what is your plea to each of those charges here today?
No contest.
All right. I'm going to go through your rights with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you. And the right to testify at a trial yourself if you wanted. You understand all those rights?
Yes, Your Honor.
And you understand that you're giving up and waiving all of those rights by pleading no contest.
Yes, Your Honor.
Also, your only appeal of your plea here today would be by leave to the Court of Appeals. That means you don't have an automatic right to appeal it. You'd have to ask that court to hear your case. They said no, that would be the end of any appeal. Do you understand that?
Yes, Your Honor.
Has anybody threatened you with anything to get you to plead no contest?
No, Your Honor.
Has anyone promised you anything other than what we've said here in court today?
No, Your Honor.
And is it your own free choice to enter this plea?
Yes, Your Honor.
All right, with regard to file number 6780, which is the aggravated stalking count, I'm reviewing Michigan Police, State Police Report number 734060-24. I've marked that as Court Exhibit 1. Mr. Trush, have you reviewed that report?
I have.
Would you agree that the information contained within that report would provide a factual basis for finding guilt as to the charge of aggravated stalking?
Yes, Your Honor.
Mr. Zola.
I would concur.
Then with regard to file number 246776, which is the unlawful driving away, I'm looking at a probable cause affidavit that references complaint number 24169000991. Have you reviewed that, Mr. Trush?
I have.
And do you agree that that would provide a factual basis for finding guilt as to that charge?
I do.
Mr. Rolla.
Yes, Your Honor, I agree as well. Thank you.
So the court will mark and admit that report as Court Exhibit 1 in that file as well. Mr. Haas, had you previously been convicted of unlawful use of a motor vehicle back in 2023 here in the 46th Circuit Court?
Yes, Your Honor.
So I believe that would provide a factual basis for the habitual enhancement. Mr. Rolla, are the people satisfied with the factual basis for the charges in each file?
People satisfied for sufficient factual basis to accept the defendant's no contest pleas as to both cases 246776 and 246788.
Mr. Kirsch.
I believe the court has a factual basis.
Mr. Rolla, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Church.
I'm aware of none.
Mr. Rolla, are the people satisfied that the court has complied with statute and court rule in the taking this no contest plea?
Yes, Judge.
Mr. Church.
I am satisfied.
Mr. Haas, the court finds that your plea is knowing and voluntary. The court is satisfied based on Court Exhibit 1 in each of the files that there is a sufficient factual basis to support a finding that you are guilty of the charge in each file. Court will accept your no contest plea as to each. We will set this for a sentencing hearing. In the meantime, someone from the probation department will be in touch with you for a pre-sentence report. Mr. Roll, anything further that we need to address in this file today?
Just that the court takes off the calendar the jury trial.
Yeah, in light of the plea, the court will remove the jury trial. It's currently set for April 16th.
Thank you, Your Honor.
Mr. Trush.
Nothing further.
Okay. Thank you, Mr. Haas. That's all for today. Is there an officer in the room there with you?
Yes.
Yes, Judge.
Okay, if we get Mr. Woodward next, please.
Yes, sir.
Thank you.
You know, I did see Mr. Lundy out in the hallway. I've not seen Mr. Ball check in yet, but
Okay. Let's take care of Mr. Woodward's case and then we'll. That's just yesterday. A lot of time.
Right, sir, are you Michael Woodward?
Yes, Your Honor. Yes, Your Honor.
On record in People versus Michael Woodward. This is file number 256797, 6798, and 6799. The record should reflect Mr. Woodward is appearing today by video from Otsego County Jail. If I could have counsel put your appearances on.
Thank you for the record from the people.
Thank you, Your Honor. Richard Trish, appearing on behalf of Mr. Woodward.
Mr. Trush, can you tell me the status of these files today?
Yes, Your Honor, we've been in negotiations with the prosecutor. Unfortunately, this time we don't have a resolution of the matter. I would ask that they be docketed for trial.
Mr. Rolla, is there going to be a request for joinder of these files?
And again, that would be the situation in regards to the two retail fraud files, as in fact, they arose out of exactly the same circumstances, very closely connected together. As to the RNO case, I don't have to look at that as to whether or not that would be joinder. I would indicate as well for the record, there was a plea offer in this file that would have encompassed all three files under the court's permission. I'll state it for the record.
Okay.
Thank you, Your Honor. As to file number 256797, that page, it's a retail fraud first degree. That would be pled to as a habitual second, full restitution. Same situation applies to file number 256799, retail fraud first as a habitual second with full restitution. And as to file number 256798, FH, that's the resisting obstructing case that would be pled to as a habitual third. In return, should the defendant have chosen to accept that or chooses to accept that, then obviously the other enhancements would be dismissed.
Mr. Trush, are you going to be objecting to joinder of the two retail fraud files?
I don't expect to object to those. I think, like the prosecutor indicated, though, it might make sense for us to discuss the other one. There's some overlap with witnesses, I think, with the retail frauds, not as much, I think, with the other one.
So I'm in the dockets, file number 6797 and 6799 together for trial. And those will be tried first. Mr. Rolla, how many days of trial do people need to try those two charges?
2 days, maybe, Judge. I don't even know if it's going to take that long, quite frankly.
Mr. Church?
Personally, I would have thought 1 day myself.
And again, I think we could probably, since they're joined, we could probably get them done in 1 day. I just say 2 days just because I don't know what if anything, the defense was going to do.
I'll set it for a 1-day jury trial. Mr. Rolla, how much lead time do you need to be ready for trial in that case?
60 days to the outside, 30 is probably enough. I doubt the court may be able to fit it in its docket in that time period.
Thank you, Mr. Church.
That time period would be fine with us.
Okay, I'll set it for a 1-day jury trial at 60 to 90 days. I will set it for a final status conference on the motion day immediately prior to trial. That will act as the motion and plea cutoff. So Mr. Woodward, there'll be one more hearing before your trial date. To the extent that you want to further consider any plea offers, that final hearing prior to trial would be the last date to enter a plea, okay?
All right, Your Honor. All right.
Mr. Rolla, are you anticipating any motion practice?
The only one would be, of course, the motion to consolidate, I think, at this point in time. And again, if that's the case, then there's obviously no need for a full 4B609 motion. The cases are being tried together.
Mr. Trish, are you anticipating any motion practice?
I don't anticipate that. And just so we make a clear record, the court is consolidating the two retail frauds already. The consolidation issue is only as to the R&O.
Correct.
And again, if we're going to bring a motion, it would be brought as to the R&O joined with the other cases. If I don't think it's appropriate, it's my understanding the court record already indicates consolidation has been granted as to the two retail fraud files, as there's been no objection to the defense in that regard.
Mr. Rolla, any other scheduling dates that we can address for your side today?
Not as to these files. Thank you.
Mr. Church.
Nothing further.
Okay, and then just for the record, once retail fraud cases are tried if there's no motion and no consolidation of the, the R&O charge. That'll be set for trial following the trial of the first two. Mr. Woodward, do you have any questions at all about how we're going to proceed with your cases?
No, thanks, Your Honor.
Okay. All right. Thank you. That's all for this hearing today.
Thank you.
Anybody else, Your Honor, at this time?
I think the next one would be Mr. Knutson, but that's not till 10:45.
Okay.
Okay, thank you.
Thank you, Your Honor.
Mr. Lundy.
Who we look for?
Kristen Lundy. Lundy, maybe you come right up to the podium here, please. On the record in People versus Tristan Lundy, this is file number 236668. The record should reflect Mr. Lundy's present here in the court today.
For the record, I don't have people.
Thank you, Your Honor. Richard Church on behalf of Mr. Lundy.
Is this an arraignment on a probation violation today, or?
No, this is the hearing for the violation, although we're not going to require a hearing.
Okay, how did you want to proceed today?
So I've had communications with Mr. DeLeo. We would be admitting to the non-technical violation, count 1. That would be a violation of state law, and I believe the remaining would be dismissed.
Just looking for a copy of the violation. Is there any kind of sentencing agreement?
There's not. Admittedly, from my discussions with Mr. DeLeo, I think he's going to be recommending terminating probation. But given those circumstances, I expect the court's going to want PSI, so some background information.
Oh, Mr. DeLeo.
That's an accurate statement, as far as the plea.
Okay. Mr. Lundy, have you had a chance to talk to Mr. Trush about entering this plea here today?
Yes, sir.
Is that how you wanted to proceed?
No, not really.
Okay.
I wanted to be supervised because I know that that's what I need.
Okay, that's kind of on the outcome side of things, but I'm asking if you want to plead guilty to violating your probation today.
Oh, yes, sir.
Okay. You raise your right hand, please. You solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Mr. Lundy, you understand that you have the right to have a hearing as to whether or not you actually did violate your probation?
Yes, I do.
And you understand that by pleading guilty today that you're going to be giving up that right?
Yes, sir.
Also, by pleading guilty, it could subject you to the maximum possible penalty on your underlying charge, which is up to 2 years. Do you understand that?
Yes, Your Honor.
With all that in mind, what is your plea to the probation violation here today? Anybody threatened you with anything to get you to plead guilty?
No, sir. No, Your Honor.
Has anyone promised you anything other than what we said here in court today?
No, Your Honor.
Is it your own free choice to enter this plea?
Yes, Your Honor.
Are you pleading guilty because you did violate your probation?
Yes, Your Honor.
Back on January of 2025, were you on probation out of Otsego County?
Yes, Your Honor.
And were you aware that one of the conditions of your probation was that you were to update your probation agent with any changes in residence and that you were to comply with the Sex Offender Registration Act.
Yes, Your Honor.
And did you fail to do that at that time in January?
Yes, Your Honor.
All right, the court finds that the plea is knowing, voluntary, and accurate. The court is satisfied there's a factual basis to support a finding that you did violate your probation. The court will accept the guilty plea. I will set this for a separate sentencing date. At that time, Mr. Lundy, you'll be able to tell me what you want to tell me in terms of how I should proceed with your probation. And so that would be the time for us to talk about whether you should be continued or discharged. Okay. So make sure you talk to Mr. Trush about that so that we can address that at that time. You can get all the points that you want to make out. Okay. Mr. DeLeo, anything further on this case today?
Nothing, Your Honor. Thank you.
Mr. Trush?
Nothing further.
Okay, that's all for today, Mr. Lundy. People versus Eric Ball, case number 236597. Just connecting the attorney. This is Mr. Rolo. This is not your case,
Correct,
correct?
Your Honor, it's an AG case.
Can anybody hear me?
I can hear you. I can't see you.
Yeah, I'm trying to, it's not allowing me to engage with my camera. I don't know why.
Well, we can proceed just with audio if you want to continue to try and work that out.
That's-
Counsel, can
that's
you,
fine.
all right, can you put your appearance on the record, please?
Yes, good morning, Your Honor. Robert Mirke, Special Assistant to the Attorney General, here for the people.
Okay, and you're appearing on the Ball matter, is that correct?
Yes, indeed, Eric James Ball.
All right, thank you. Again, this is file number 236597. The record should reflect Mr. Ball's present here in the courtroom today. Mr. Trush, if you want to put your appearance on.
Thank you, Your Honor. Richard Trush, appearing on behalf of Mr. Ball. Your Honor, the court may be aware, we reached out to the court yesterday looking for a new date. I've been in communication with the Attorney General's office, Ms. Ashley Messer. I contacted them and sought an adjournment of this. So the court may recall some of the factual background. The underlying front of the court matter, when we were here last, we had indicated there's action that's taking place on that is potentially going to wipe away a significant amount, if not all, of the arrearages. Unfortunately, that hearing isn't set until May 15th, I think, 15th or 14th. I reached out to the Attorney General. They got back to me yesterday, and they were agreeable to stepping to adjourn it. We contacted the court and got a new date. Unfortunately, though, by the time all that happened, I wasn't able to get it executed to get back to the court. So I would be asking the court to adjourn the matter. And again, we already had a new date and time set. Court, give me a moment. We were provided with 5/19 at 9:15 a.m.
Okay, Mr. Mirke, were you able to hear that?
I did, Your Honor, and I did in fact review the email that was sent on or about the 2nd of this month. I don't see the response regarding the agreement to an adjournment. I guess the concerns that I have, I'm going to approach this as if it's being asked of me today without history, is that I'm not quite sure where in the scheme of things this is all going to make a difference. It was explained to the defendant that the period with which the indictment, the information covers, is not included in the order of forgiveness, and so I'm a little bit at a loss as to where we're going with this.
Okay, so are you not agreeing to an adjournment?
I would not agree to an adjournment. However, if defense counsel can produce that email from my colleagues at the office that agreed to it, I would be more than willing to allow that, but I don't see that in the file.
Okay, Mr. Trush, defense counsel is going to, looks like he's attempting to retrieve that right now, so if you can just hold on for a minute.
Thank you, Your Honor.
So I'm showing the prosecutor in the courtroom here, the email from the Attorney General on Mr. Ball's case, the emails from yesterday, Ashley Messer, saying that we would agree to an adjournment until the family court hearing. Email me a stip and I'd be happy to sign it.
And Judge, for the record, as an officer of the court, I'd indicate that it is indicating, it shows it's from Miss Ashley Messer, Assistant AG, Financial Crimes Division, Lansing, Michigan, with her phone number and fax number, stating specifically that Mr. Trush just placed on the record.
Okay, were you able to hear that, Mr. Merkay?
I did, Your Honor. I'm going to withdraw my concerns and allow the adjournment, or at least stipulate to the adjournment.
Okay. All right, based on the stipulation of the parties, then, Mr. Trush, if you can follow that with the written stipulation, you probably already have. I was in court in Calcasta yesterday and I haven't seen it yet, so.
Well, and to be frank with the court, the issue with that was by the time all the information got to me, I had no ability to access the internet.
Okay.
So I certainly will follow that up today.
All right. So when should the court set this for a sentencing hearing?
So
In June?
well, the date that we were provided, which I think should be sufficient because we should be past that front of the court date. So we were provided the 19th of May at 9:15 a.m.
Okay, from Jennifer?
Yes.
Okay, then we're already set. We don't need to schedule it. She's gonna schedule for the 19th.
Okay, and just to be double extra safe, I'll follow up with Jen and make sure.
Okay, very good. All right, thank you. That's all for today.
Thank you, Your Honor.
Thank you, Mr. Merkay. You're free to disconnect at this time.
Thank you.
Is Mr. You know if Mr. Ceslick's here?
I do not. I do see somebody out there. I think it's Mr. Brown. Just Brown.
Is there, Steve, is there a Michael Ceslick out there for anyone at all?
Nobody else out here.
Okay, thank you. We'll go on the record in People versus Michael Ceslick. This is file number 236612. If I could have counsel put your appearances on.
Thank you. For the record, Michael, people.
Thank you, Your Honor. Richard Trush, appearing on behalf of Mr. Ceslick.
This was set for sentencing on the delay. This was set for 9:30. It's now 9:40 by my clock. Mr. Ceslick is not present. If you had any contact with him, Mr. Trush.
I have not, Your Honor. I reached out to him via phone call, email, and text message. Didn't get any response. We searched him through VineLink to see if we could find him lodged in another jail. And we're not able to confirm that he's in any jail.
Mr. Rowland.
And again, I obviously would have no contact with these, Mr. Sestak, running through my office. It's somewhat unusual that when a person is given the benefit of a delay of sentence, that they choose not to take advantage of it when they can. Because again, this was having it reduced to a misdemeanor offense of receiving and concealing over 200 but less than 1,000 as restitution for the whole. And I see the recommendation in this case, and obviously it would be far less than what Mr. Sestak would be facing under the charge he's currently has before this court. So I don't know exactly. I mean, I suppose I could take a hardline stance and say, look, he's not here. He hasn't meet the conditions of the delay of sentence. The felony conviction should just stand. But perhaps if Mr. Trush wants to try and get his client for another date, then I'm not going to object. But if he doesn't show up for that, then he loses. Mr. Sestak loses the benefit of the delay of sentence, or the court can simply just do a show cause.
So this has been an ongoing issue. Mr. Ceslick has failed to appear numerous times, both on the original sentencing where he was put on the delay, and I believe he failed to appear a number of times, and the court had to issue a bench warrant, even place him on the delay. based on the information that's provided in the updated report and his behavior while on the delay, which has been less than compliant, to put it mildly, I think a bench warrant is appropriate. So I will ask that the people prepare a bench warrant for Mr. Ceslick's
Thank you,
arrest.
Your Honor.
We'll proceed further once he's arrested and brought before the court. Mr. Schuster, need a minute to talk to Mr. Brown.
We should be ready.
Okay. Let me grab it. Brown, if you'd like to come out to the podium, please. On the record now in People versus Clinton Brown, file number 256806. The record should reflect that Mr. Brown is present here in the courtroom today. If I could have counsel put your appearances on the record.
For the record, Your Honor, Michael People.
Thank you, Your Honor. Richard Church, appearing on behalf of Mr. Brown.
This is the date and time set for a sentencing hearing in this case. Mr. Brown, did you have a chance to go through the pre-sentence report and talk to Mr. Trush about that?
Yes, I did.
Mr. Trush, are there any additions, deletions, or corrections to that report?
There is, Your Honor, on the CFJ 145, page 1, the pre-sentence investigation report. They have me listed with my first name as Larry, obviously a typo.
Oh, yeah, and okay, we'll correct that.
That was the only correction I had.
Oh, and these are both misdemeanors, so there are no guidelines. Mr. Bullitt, do you have any additions to corrections?
No, Your Honor, I do not think.
Mr. Trush, can you slide that podium towards the fence table? How it always gets moved. Never see Mr. Roll. So, okay. Mr. Roll, anything by way of allocution on behalf of people?
Briefly, Judge, this is a situation we're looking at the defendant's blood alcohol of 0.193. I think probably accounts for his actions on the date and time in question. There's a recommendation that people have no objection to the court following, as the defendant was allowed to plead 2 counts of attempted resisting obstruction. Thank you, Judge.
Mr. Trush.
Thank you, Your Honor. I would agree with the prosecutor insofar as I think clearly the blood alcohol content here is a driving factor. I think Mr. Brown is going to tell you he has a problem with alcohol and he should and needs to stop. I think he's also going to tell you he had a period of sobriety where he was doing well. He was counseling, he was engaged with a counselor and really being successful. The counselor moved and unfortunately, rather than do what he should have done, which is reestablish with a different counselor and rebuild that rapport, because I understand part of the issue there was he had this rapport with a counselor and kind of starting over from scratch can feel like a big task. But I think that's what he needed to do, and that's what he should do. I would suggest to the court, though, given that there's no prior felony history, I think upfront jail is not the appropriate way to proceed. And what I would suggest to the court, we know that with the sentencing reforms, right? If he had pled to the felony, didn't have the benefit of that bargain to a misdemeanor, his scoring guidelines would start with a 0, which would mean he'd have a presumption against jailing. It seems backwards to me that because he got the benefit of a plea agreement, because he doesn't have a substantial criminal history, that he's sort of backwardsly going to wind up with a worse recommendation because of that. What I think would be appropriate, I would suggest to the court, maybe extending the probation from 6 months to a year. I think more supervision is probably a good thing for him, something that would benefit him. And perhaps holding that in jail or even more jail in abeyance is a better idea. I think, frankly, that will incentivize Mr. Brown to continue to do the right things, continue to address his issues. I think it also, it contains the benefit not only of giving him that incentive, but he has the supervision. And if he does mess up, the court has the ability to violate him and impose the jail. I think that is something that would benefit him and benefit sort of society in general more than a short jail sentence. Thank you.
Thank you. Mr. Brown, anything you wanted to say?
And for what it's worth, I have been working on my alcohol prior to this. It's just a lapse that I had. And I have mental and physical like illnesses going on. So it just took over and I didn't do it the right way properly, you know. But I've before that happened, that whole year before this, I've been working really hard not to, I've been going good, sobriety, whatever. I smoke, but that calmed my nerves mostly. And I could do without that even. I used to work in the oil field, but random drug screenings and everything. I have no problem with that. It's just a lapse. I just want you to know, I've been trying to control this alcohol problem that I have. I know I have one. Obviously my record shows that, you know, but I'm really trying to get a hold of it. And I have a family and friends that are trying to help me do that as well. And it's been going good, but this time they were gone. So I was just left my own devices and I didn't do it right.
All right, I did read through the report. I am familiar with your background and your circumstances, and you know, your physical and mental health issues that you're trying to deal with. And I can accept that those played a role in what happened in this circumstance and just generally your issues with using substances. And I do think a period of probation is appropriate. Through probation, they may be able to connect you with some resources to help you deal with those things in a more positive way. So I do think probation is appropriate. And of course, the restitution is appropriate for the bill that wasn't paid. I think if this was, you know, if the facts have been different, I might be more inclined to agree with Mr. Trush that the punishment component should be held in advance, depending on your performance on probation. But, you know, the facts here are kind of aggravating. You know, you really engaged in some pretty outrageous conduct. I understand that you were blacked out. You don't remember it. You didn't have necessarily control over your actions. That doesn't necessarily make it better from the standpoint of everybody else who was encountering you in that state. You caused quite an issue there, and presented a danger both to yourself and people who were traveling on the road when you were going back and forth across the road. Certainly presented a danger to the police officers that were involved in trying to get you under control when you were in that state. And I think all of that warrants some punishment for you. And I think it's important for the community to see that that's just not behavior that doesn't go without some type of punitive aspect to a sentence. I do think work camp is appropriate. I don't have any objection to your participation in the work camp program, which will allow you to be out of the jail itself, but still under the jurisdiction of the jail. In fact, I think in this case, it might be a real positive thing. So I am going to follow the recommendation. I think it's well crafted and I think it addresses all those concerns that I've stated. The court is going to place you on probation for a period of 6 months and going to adopt as the conditions of your probation all the terms and conditions that are listed in the report. The court is going to order as part of that probation that you pay restitution in the amount of $48.50. That's to be paid to the Otsego County Clerk to be dispersed to the Pine Squirrel Bar and Grill. Crime victims assessment of $130, court costs of $325, attorney fees of $350, $68 state cost, and supervision fee while you're on probation of $30 per month. Court is going to order that you serve 30 days in the Otsego County Jail. You do have credit for 2 days served. I don't have any objection to your immediate release to the work camp program. Because this is a misdemeanor, or these are misdemeanor offenses, there are no written appellate rights, but you do have the ability to seek an appeal of the sentence. If you wanted to do that, you would need to file the appropriate paperwork within the next 21 days. If you have more questions about that, Mr. Troop should be able to explain that process to you. Mr. Rolla, anything further that we need to address here today? Mr. Troop. I'm probably going to go with the officer, but I am going to provide the jail with a note indicating that I don't object to your release. Okay, next hearing set for 10:30 with Mr. Brokaw will be in recess. Mr. Bader, have you seen Mr. Brokaw yet?
Not in building, but I have been in communication with him in the past half hour in regard to the location, the fact that he comes today.
Okay, he's not here yet, though.
Unfortunately, Judge, he is not.
Okay.
My next one is with Mr. Nudson at 10:45. He is currently still lodged.
Okay, they will have him ready at 10:45 from jail. Steve, is there a Miss Lazinski that's?
None of these folks that are in here now actually have a chance to get to watch another.
Okay. All right, let's take a short recess and we'll go forward once we have.
Yes, John.
Are you Mr. Knudsen?
I am, Your Honor.
We're on the record now in People versus Adam Nudson, case number 25-6800, 6801, and 6822. The record should reflect Mr. Knudsen appearing today by video from Otsego County Jail. If I could have counsel put your appearances on.
Thank you. For the record, Mike Roll, on behalf of the people.
Jonathan Neighbor on behalf of Mr. Newton.
Okay, these are set for status conference today as well. Mr. Faber, you filed a motion to withdraw as counsel, is that correct?
That's correct, Judge.
Let's address that first. I did have a chance to review your motion. Was there anything that you wanted to place on the record today?
Just Judge, it was a very brief motion, but I do believe based upon what I did place in the motion, it's good cause for the withdrawal at this point in time. Obviously, I'd like to get Mr. Newton counsel through the indigent defense as soon as possible. These cases are moving forward and we've got to get someone else to step in and get up to speed rather quickly. It's a situation where I believe I dropped the ball in the representation on the bind over aspect of this case to the point that unfortunately the attorney-client relationship has broken down. Understandably, Mr. Knudsen was informed of one thing and something else totally different is what he's facing with respect to the plea bargain. So respectfully, Judge, I hope that this court would grant my request. I spoke to the prosecuting attorney. They don't seem to have any objections to me withdrawing. So we ask the court to follow through with that.
All right, Mr. Knudsen, have you had a chance to talk to Mr. Faber about his withdrawal as your attorney?
I have, Your Honor.
Do you have any objection to that?
No, Your Honor. I am actually in the process of acquiring private counsel as we speak. I would just respectfully request that the court appoint me public counsel so that I'm properly represented in the proceedings in the interim.
Okay, that was going to be my next question. So, all right, and Mr. Rolla, do the people take any position?
Judge, don't people take is that Mr. Knudsen, should the court grant this motion, is agreeing to waive any delay or objection in regards to any claim of delay of justice, because by getting new counsel, there's going to be a delay.
Okay, I understand your point. I don't think I can condition the granting or denial of the motion on his waiver of that. So.
Perhaps, maybe, my apologies, Judge, maybe I didn't state it correctly. We have no objection to the motion. I just want the record to reflect that if upon this court's granting the motion at the defendant's request, he is waiving any speedy trial claims caused by the delay.
Okay, I think there may be, arguments both ways on that. Regardless, that's not an issue that's before the court. We do have that, your position on the record, Mr. Rolla. I do find that it would be appropriate to allow Mr. Faber to withdraw as counsel. Mr. Knudsen, the court will appoint new counsel to represent you. I will set this for a hearing at the court's next available date so that we can discuss how to proceed with new counsel until you retain your own counsel. And Mr. Faber, if you can notify Mr. Keel's office.
I will, and I can draft a simple order for this court signature reflecting the decision today.
Okay, that'd be great. Thank you.
Hey, Judge, this is for all 4 files?
Correct.
Thank you. I just wanted that to be clear on the record.
So Mr. Knudsen, you'll receive notice of the next date and hearing time along with who your new appointed counsel will be, okay?
Thank you very much, Your Honor. I appreciate that.
Okay, thank you. That concludes this hearing and the court's going to disconnect at this time. Mr. Brokaw.
Thank you, Your Honor. Unfortunately, Judge, Mr. Brokaw is not present. I've attempted communication via phone call and text. Unfortunately, those are not being returned, so I have no representation of his whereabouts other than I can represent to the court that there was communication at 8:30 this morning.
Mr. Rolla, as to Mr. Brokaw's case, and this is file number 256796.
Thank you, Your Honor. For the record, my phone bill people. It's the situation where sentencing, we entered, we had everything done. I'm kind of surprised that he didn't show up, other than there could be only one reason we wanted to avoid potentially consequences of sentencing. That being the case, the people request a bench warrant.
Okay, based on the fact that there has been a plea entered in this case, there is a recommendation for 12 months of jail. I find it would be appropriate, given that Mr. Brokaw is no longer entitled to pretrial release because of plea. Court will grant the request and will sign a bench warrant for Mr. Brokaw's arrest. The court will order that his bond be revoked and that he be held at the Otsego County Jail until the court can get him set for sentencing once he is apprehended. Do we have a Miss Lazinski?
Yes,
Mr. President. Ms. Lazinski, if you can come up to the podium, please. Right, and this is file number 246694. Ma'am, you're Ann Therese Lazinski, is that correct?
Yes, sir.
Okay. And Mr. Baber, are you appearing as duty counsel for purposes of arraignment?
I am judge at the request of you, standing in for the attorney who normally does this.
Okay, so Ms. Lazinski, you're before the court today based on an allegation that you violated your probation. Have you been made aware of what the alleged violation is?
Yes.
Okay. There's a few things I need to go through with you with regard to your rights. First of all, you do have the right to have a hearing as to whether or not you actually did violate your probation. You also have the right to have an attorney present at any subsequent proceedings. If you can't afford an attorney, one will be appointed for you at public expense. Mr. Baber is here for purposes of this hearing today if you want to consult with him. If you are found guilty of violating your probation, it could subject you to the maximum possible penalty on your underlying charge, which is up to 5 years. Do you understand that?
Yes.
Mr. Baber, have you had a chance to talk to Ms. Lazinski about how she wants to plead?
Yeah, she will be pleading not guilty at this point in time and asking the court to set this for a formal hearing.
So the court will enter a not guilty plea on behalf of Ms. Lazinski with regard to the alleged violation. Ms. Lazinski, did you want to request a court-appointed attorney to represent you? Okay.
I reviewed her financials. Nothing's changed. She's still qualified.
Okay, so the court will enter an order approving appointment of counsel and referring this to Mr. Kilo's office, who will assign an attorney to you, and you'll be notified of who that is, okay? The court will set this for a hearing. Pending that hearing, Mr. Julio, do probation take any position on that?
Your Honor, Ms. Lazinski is still reporting to her probation agent. There's not any other alleged violations of probation. So a PR bond would be appropriate.
Okay, so Ms. Lazinski, you aren't going to be required to post any money for bond. The court will issue a personal recognizance bond for you pending that hearing. That's going to be in the amount of $500, which may be responsible for if you fail to appear for any future proceedings. I'm also going to include as the conditions of your bond, all the conditions of your probation. So you need to continue to abide by your probation until we have that hearing set. Because it's a PR bond, the court will likely set this at its next available date, although that may not be within the 14-day period. You'll be notified of the date and time of that hearing, as well as your appointing counsel. Do you have any questions? You need her to meet with you today, Mr. DeLeo. I know you're not the supervising agent.
I don't, Your Honor. She just needs to continue to contact the supervisor.
All right, thank you. That's all for taking.
See you this afternoon.
Okay, thank you. Mr. Steffi, were you ready with Ms. Pilaski? Look forward to the podium, please. We're on the record in People versus Pilaski. This is file number 246716. Have counsel of your appearances on the record.
The record, Your Honor, Michael, on behalf of the people.
Good morning, Judge John Steffi, on behalf of Ms. Pilaski, both present before your honor for sentencing.
Thank you. This is the date and time set for sentencing hearing. Just so council's aware, both counsel, I received numerous letters on both sides, lots of materials, very thick packet. I did have a chance to review all of the letters, everything that was submitted from both sides. So I just want to make sure the record is clear on that. Council are aware. I also did receive your sentencing memorandum, Mr. Steffi. I had a chance to review that as well prior to the hearing.
I appreciate you doing so, Judge, and the delay was largely in part because I couldn't come back home during the ice storm.
It's been difficult for everybody to navigate that past week. So all that being said, Ms. Pilaski, have you had a chance to go through the pre-sentence report and talk to Mr. Steffi about that?
Yes.
Mr. Steffi, are there any additions, deletions, or corrections to that?
No, Judge, thank you.
Are there any challenges to the scoring of the guidelines?
I don't have a switch.
Thank you. Mr. Rolo, do the people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the scoring of the guidelines? Do you have any victims that wish to address the court today?
Yes, we do. Again, we have two that are conduct and rights advocates going to be advising the court of. And then there are a number of other family members. I've advised them that their ability to speak is discretionary with the court.
Okay. So, Mr. Steffi, I'm going to have you and your client have a seat at the fence table. Mr. Rolla, have our first.
They stand up together.
Sure. Ma'am, are you the person who's going to give the first statement?
Yes.
Okay, can you tell me your name?
My name is Tina Kuka. I am the eldest daughter of John Sharp.
Okay, and we're making a transcript. Can you just spell your last name for me?
It is Kucka.
All right. What is it that you would like to say today?
I want to start off by saying that John Sharp was born in Detroit, Michigan, to Ted and Emma Sharp. To know John, we need to understand what he was made of more than where he was raised and what his social status was. His mother was born to German immigrants and born in their family home in what is now East Point, Michigan. She had an 8th grade education and she was needed in the house after her mother passed away to help the family duties. So you could say she was a chef cook, bottle washer at a very young age. His father, Ted, was a strong man with only a 6th grade education, but he was smarter than most people in this room. Ted was the honest, hardworking hero of a man. He never lied, never backed down when a weaker man would. John got a lot of his personality from his father. Ted was a World War veteran that earned Army commendations, medals with 3 oak leaf clusters, a European campaign medal with 2 oak leaf clusters, and a Purple Heart with an oak leaf cluster. As a civilian, Ted was in automatic industry for his entire life. There wasn't a thing out there he couldn't fix. John, too, was in the military. When he graduated from high school in 1968, he was drafted into the Army. John did his basic training at Fort Knox, Kentucky, and he advised advanced military training with a fort at Fort Meade, Maryland. He was a heavy equipment specialist. He worked on heavy wheeled and truck vehicles. Like his father too, received Army Accommodations Medal with 1 oak leaf cluster. He was awarded the Combat Infantry Badge, a driver's badge, another hero. He was a hero. John had 2 brothers, Ted and Bob, and a sister Maureen. But this is about John. Prior to being deployed to Vietnam and going to boot camp, he met Deb. Deb was his true love, and he knew it was the first time, knew it from the first time he spoke to him. Debbie had the voice of an angel and was a gift from God just for John. Debbie moved across the street from John's house and they became very close. He proposed to her just before he was to ship out to Vietnam. It wasn't a romantic down on one knee kind of thing. They wanted to have some privacy in a house full of family at Christmas time. So they were kind of hiding on the stairways and he asked her to marry him. She did say yes. After his deployment that lasted over a year, John returned home. He was slightly broken when he got home. And if you have any military experience, you know what that means. John and Debbie got married and they got assigned to Fort Sill, Oklahoma, where John completed his military career. The cool thing after they returned to Michigan is they moved into the house across the street where John's family lived, just 4 doors down from Debbie's mom lived after she remarried. And it happened. Debbie was pregnant with their first child, Tina. Took a few years, and then Samantha was born. They raised the girls downstate until John had a chance to semi-retire, and they moved to God's country at Gaylord. After several years, John was dealt a blow that would hang with him until he was killed. He lost his wife. He never got over that. Sure, he still did the things he loved, but his best friend was gone, and she died in his arms. A few years later, tragedy struck again, and his father died with John by his side holding him close. He still had great wealth, as he had his 2 girls and 8 grandkids, some who lived in the same home as John. He was a great dad and a grandfather. He was a role model to all his children and grandchildren and those who knew him. So you see, John was not just some old guy that got hit by a car and died. He was a son, a big brother, a great father, grandfather. He was going to be a great grandfather had his life not been taken away. He was one of the brave. He will be missed by many and never forgotten. Your Honor, as I said, I am the oldest daughter of John Sharp. My father was many things to many people. He was a son, a brother, a cousin, a husband, a dad, an uncle, godfather, papa, father-in-law, and a friend. He was loving, caring, kind, nurturing, and a hero. He enjoyed sports, hunting, fishing, and camping, and spending time with his family. At 18, my father was drafted into the Army and served in the Vietnam War. He was on the front lines working as a mechanic. After his service, he became a car mechanic and a construction mechanic. He worked tirelessly from dawn to dusk to provide for his family. We may not have been the richest family, but we had a roof over our head, food on the table, clothes to wear, but most of all, we had his love. His love for the family was what made us the richest in the world. Every year, Dad ensured we took vacations with his brothers and sisters and their families up north. Dad loved the outdoors and the country living. That's the reason he retired to Gaylord. He instilled in us the importance of tradition and family, constantly learning new lessons from him. Lessons he passed down to his kids and grandkids. Dad was so proud of his family, his children, siblings, nieces, nephews, and most of all, his 8 grandkids. Unfortunately, he will never get to see them all graduate from school, see them get married, or even get to meet his great-grandchildren, which I know he was patiently waiting for. He had so much more to offer, more lives to touch, more friends to make, and more stories to share. Now we must carry on those stories. Let me take you back to that day and the days and the months that followed for my life, our life. It was an ordinary day, enjoying time at work, my coworkers, and I heard that there was an accident in Hayes Tower, Van Tile at 11:21. Initially, no one knew who was involved, but some of us had family in that area, so they began checking in with them. I didn't think to text my dad, as he wasn't typically out around that time due to his kids and grandkids being at work or school, and it wasn't time to pick up the grandkids from school. I finished my lunch, and I go back to my desk to check if any names were updated as I worked for the hospital. Not knowing once I hit that button, my life would change forever. As soon as I opened the dashboard, I saw his name, John Sharp, trauma. At that point, I could not get answers or to the hospital fast enough. I had a coworker drive me, and in the meantime, I was in touch with my sister, who met me down at the ER, as she works on the other side of the hospital as well. As soon as I walked through those doors, I was escorted into the room. I'm way too familiar with that room, because that's where they took us when my mom passed. I heard my sister's face. I knew the news we were about to receive wasn't anything good. After what felt like hours, medical examiner and the police officer came in to tell us that Dad was hit by another driver and they couldn't save him. I was numb, in shock. I didn't know what to say, what to feel, or what to do. What do I do next? Who do I call first? How am I going to tell my kids? How do I explain this to his siblings and their families? I sat and collected what little bit of thoughts I had and started making some phone calls to family and started getting the family together. What seemed like another eternity, the doctor that worked on my dad finally came in and explained she did everything possible, but she couldn't save him. She still couldn't tell us for sure what had happened, and the rest was ultimately left with the police and the autopsy reports. They suspected that he may have had a stroke or heart attack while driving, but to rule any of that out, we had to wait for an autopsy. The thought of everybody cutting and prodding at my dad was just unreal. Afterwards, she asked if we wanted to go back and see him and have time to say goodbye. I've been taken to hospital rooms several times to see my dad in the past. But when we entered, we always got to laugh and joke with him. This time, no. No one got to say anything. But how? How could this happen? Going into a room where we can see and touch him, So my head going through my head, trying to understand why I can't hear his voice. So many scenarios are going through my head, trying to understand how this could happen. There's a stop sign at that intersection. What happened? Did he have a heart attack and black out? Yeah, did the other driver even stop at the stop sign? Were they just assuming that the other driver stopped so they didn't have to? What were they doing? Were they drinking and driving on their phone, not paying attention, under the influence of drugs? I have no idea. But that stop sign has been there for as long as I know. So my question, so many questions that no one can answer. All I can do at this point is think, pray, and hope that he didn't suffer no matter what happened. We stayed and prayed over him for over an hour, hoping this was all just a big dream, and that he was going to wake up and say, I'm okay, I love you. But it didn't happen. He just made their life was so cool. He was never that cool. We began to say goodbye for our beloved dad and Papa. They are ready to take him down for his transport to do the autopsy so we can get further information as to what happened. As night goes on, we are seeing pictures of the crash on Facebook and on the news. Still trying to wrap my head around what just happened. That beautiful sunny morning. Over the next few days, the family begins to gather to start planning for his funeral, all while still in shock. One day I'm talking to him, and days later, picking out a casket. I'm picking out the last outfit that he will wear. Needing to go through his personal things and finding important paperwork to make all the necessary calls. Social Security, the VA, everyone else that needed to know about his death. I go through the next few weeks, very little sleep. And as I'm doing a lot of thinking of what happened, after seeing all the pictures, the accidents, gotten in my emotions, anger, sad, disgusted, shamed, confused, horrified, anxious, depressed, guilty, numb, and fear of how life is going to go on without him anymore. I never knew I could feel so many emotions at once, while also not feeling a thing at the same time. Yes, it's possible. Going to the corner where the accident happened, trying to play detective myself and wrap my head around what has happened, but still no answers. At this point, all I can do is wait for the autopsy and the police report as to what has happened. The following week was hard as we prepared to say our final goodbyes to Dad. We are a week out from the accident and I still cannot sleep as my mind keeps trying to figure out what has happened. The continuous nightmares of trying to save him. Wishing that this was a nightmare and getting up and trying to call him on his phone, hoping that he would answer and tell me he's fine. And this was all just a real nightmare. But when I called his phone, all I got was his voicemail. Something he would never have done. He always answered when we called. The 26th of 2023 of October comes, and it will be the first day I see my dad again. But it's not at home. It's at the funeral home. This is when the actuality hits. And we come in and see him for the first time since being at the hospital. All the makeup that they had to put on him to cover up all the bruises on his face. My God. It doesn't look like my dad. As this night goes on, more family and friends gather to say their final respects. It's just so hard at this time to see how many lives he was touched. All the people that he showed that are showing up that I never met, from his many cowboy action shooting, MPVC shooting, friends, and the lives he impacted. Talking about the fun times we all had, and listening to the stories from the family and the friends, past, present, and navigating our future without him. How we will always remember how kind and loving he was to all his family and friends. The next day is even worse than the last, as it will be the very last time I will see him in the flesh. I know I will always see him, as he is deep in my heart, as is my mom. Just the thought of never seeing him again angers and frustrates me. Instead of sleeping, I am up and writing his finishing touches on his eulogy for him. Talked about how much we will miss him, from all the vacation rides, using the steering wheel as a guitar, or the drums, singing along to the old music that we grew up on. All the stories and the memories of him and his siblings growing up at the vacation home, and how my grandpa grew up in an old house that was fallen on the property. How they would spend their summers with their aunt and uncles for the summers working on the farm. And all the memories of so many years of vacationing in the trailer on the family property. The many summer vacations of picking blueberries and having fresh blueberry pancakes, and the fishing trips down the river. All the trips to the trailer every October and November, learning how to hunt. The endless nights he would stay up with us kids, helping our homework, and how he would even help his grandkids with their homework. The new things I was still learning from him as he was getting older and telling us things he had never told us when we were younger. All those things that I wished I could have had him write down, or the times I just wished I listened to his stories and asked more questions. But now I don't have that opportunity. Days turned into weeks, which then turned into months, as I called the funeral homes and the police departments to see if any news of what has really happened. Feeling so numb because I just want to know what happened. I just can't think right. Work is hard. I can't concentrate at all. I can think about is what happened. How did it happen? We have so many questions that no one can answer. I have lost all interest in anything in life. The things I love to do, how to feel are gone, all gone. I don't know how to feel at this point anymore. All the endless calls to everyone from the VA to the insurance companies, to attorneys, faxing and emailing document after document over and over. It was like reliving it repeatedly, trying to explain what I could yet not know the real story myself. Finally, almost 2 months later, I get the death certificate, a copy of the autopsy, and a police report. I find his autopsy report that he didn't suffer and that he died instantly from his injuries. About every bone on the left side of his body is shattered. His neck was broken and his brain was nothing but mush. If he had lived, he would have had machines keeping him alive. I read that Miss Pilaski was driving 55 miles through a 4-way stop. That was worst of all. She was under the influence of morphine that was never prescribed for her. Here come the emotions all over again. But most of all, I'm so angry. I'm angrier than angry. I am furious. I don't even think there's a word how I feel. Because I've never felt like this before. I just can't begin to process the new information. Everything is starting all over again. The nightmares, the processing, understanding how someone can do this to another person. How do I sit down and tell my sister, his siblings, his son-in-law, and all the grandkids what has really happened. At this time, I feel that this is harder to explain to everyone than it was to call and tell them that he was killed in an accident. At this point, I'm on the phone with my doctor as I cannot handle things on my own anymore. I need additional help to cope with the stress, anxiety, the depression I'm going through. I have nightmares every night trying to save him over again. I can't. I don't want to sleep at night. Some days I can't even get into the car to drive anywhere for fear of being hurt or becoming a victim in an accident myself. I can't handle watching other drivers and how they drive or photos that are on their phones. The doctors began to add and increase some of my medications to help me cope, but now I haven't been able to get through a day at work or even to try and function. A few weeks later, I need to call a therapist because I still can't take care of my body, my health, my needs. I need someone to help me. By now it is February, and it's with a heavy heart that I decided that I should take a leave of absence from work. I need to get my health, my mind back to somewhat of a real functional state. After several therapy sessions, tests from the doctor, I ended up taking not just a month, but it took over 2 months before I could go back to work. And I was still unsure if I even was ready to do that. The stress, the anxiety, the confusion, life disruptions, sadness, frustration, the days of being extremely upset, and most of all, the loss of part of our hearts. I have lost so much of my life in the last 2.5 years. I have missed work, missed fun times with my kids, lost interest in things that I enjoyed due to the anxiety and depression that she has caused in our life. Nothing can replace the missed advice, the calls, birthdays, holidays, or even many adventures we still had together as a family. We won't get to get the I love yous, and then I'm proud of you and what you have done. All we get now is a graveside and memories. Your Honor, I did not go on our vacation last year, as this was a family vacation. A family vacation that always included the entire family. I could not go as the memories are strong. Thinking of how Dad should be on the boat fishing. He should be on the beach watching his grandkids, nieces and nephews. He should be cooking dinner and enjoying his time with his brother and family. Instead, I spent over 2 months off of work trying to refine myself and how to navigate my life without my dad. Knowing that I will not have any more holidays or birthdays with him. Nightmares of trying to save my dad's life from the accident, wishing at times it was me and not him, wondering what if I were with him, could I have saved him? The many therapy sessions and doctor's appointments trying to help me deal with my dad's death. Dealing with all the other court dates to make sure my sister and her family had a place to stay, and becoming the executor of the house so she could continue to stay in the house so they didn't have to move from his house, their house. Dealing with attorneys and the insurance companies, making sure we got what we deserved, when in reality, the only thing we deserve was for this not to happen in the first place. Along with all these court dates in Ms. Pilaski, all the adjournments, let me count them, including today, 22 court dates of pain and suffering and adjournment after adjournment of games being played. The waiting, the pain, and the suffering, time and time again. She doesn't think she's guilty, and it wasn't her fault. Speaking of living lives, I hope she enjoyed her vacation to Alaska. I honestly can't believe that the courts allowed her to go on vacation, especially to another side of the United States. Whether this trip was pre-planned or not doesn't matter. It's completely unjust and unfair. What's even more frustrating is that neither she nor her attorney said anything until just a month before she was scheduled to leave. How did Ms. Pilaski even get permission from the courts to go to Alaska? Alaska is one of the few places my dad always dreamed of visiting, but he will never get the chance. My daughter was talking to me just that spring to take her papa for his birthday. He always talked about going. I believe from the very beginning that both she and her attorney knew this trip was planned and manipulated the courts. Sorry. Mr. Stuffy adjourned the case multiple times with various motions and ultimately got the court's approval for her to go on this vacation. How fitting that he was on vacation at the very time we were supposed to be in court for our next hearing. After Your Honor clearly stated that the hearing in August of 2024 needed to be determined whether we were going to jury trial or whether she would take a plea and that no further extensions would be allowed. It baffles me that someone who took another person's life, whether intentionally or not, gets to go on a trip like that while my dad is no longer here with us. He's gone, buried in the ground, and never gets to come home to be with his family. He can't go on vacation or tell us how proud of us he is. Yet she gets to be free, living her life, seeing her family every day. I'm honestly struggling to see how this is fair. Because she made the because she made a conscious choice to get behind the wheel under the influence and subsequently breaking other laws within the process. My daughter, who is planning her wedding for the spring of 2024, had to give him his invitation in the coffin to heaven with him. He was so excited to see her happy and getting married, and not just to anyone, but someone he felt she would be safe and to take care of her. He was so happy to watch her graduate from college, and now he was planning to attend his first grandchild's wedding. Now we won't be at that other granddaughter's wedding this spring, or even see the first great-grandchild being born. He will not be a living part of any of this for any of his grandchildren. He was taken away so violently from us. He loved his family and it meant the world to him. And now he's not here to experience any of it. These past 2.5 years have been some of the roughest times without him. All the first without him, and how hard it is without him, and all his silly remarks and jokes, the off-the-wall things he would say in conversation. How do you even get that back? You don't. And all you get is if Papa were here, he would say this or do this. We all then laugh, and eventually the laugh would turn to tears as we begin missing him even more once again. We now have gone through another set of holidays without him again, and still no resolution to this case as it was planned for trial in March. We've come to the date of February 18th of 2025, final status conference hearing, hoping that we hear the words that we're going to trial and that she will spend many years in prison for her actions. But instead, I am just hit with a brick. I am told for the first time that she will be pleading no contest and that she may only spend a year in county jail. And that is only maybe. She could do less or no time. What How could this be? She didn't just beat somebody up in a bar fight. She killed somebody with a motor vehicle at 60 miles per hour while on her phone and under the influence of drugs that were not even hers. This is no one, there is no one feeling that could explain how I'm feeling right now. I'm angry, hurt, sad, betrayed, annoyed, disappointed, anxious, depressed. I can go on, but as you can tell, I'm not happy. Why and how can someone stand in court and have no feelings or remorse for what she has done, or even think she is not at fault for her actions? Not once have I seen her ever say she was sorry for what she has done, but I suppose without doing so would it be admitting guilt, which she refuses to do. On October 18th, Ms. Regina Pilaski took our beloved family member. Dad survived his mom, dad, and his own wife's death. He survived 12 heart attacks, bypass surgery, and he even survived his time in Vietnam. He still had so much more of his life, but Ms. Pilaski's reckless actions stole everything from him and from us. She chose not to obey the law, to ignore the stop sign, and to drive under the influence of a prescription drug, not even prescribed to her, all while on her phone, which in of itself is illegal, unless it is through a hands-free device, which was found that she was not using after the event data recordings were investigated. She did this all at 60 miles per hour without any attempt to slow down or stop until she hit the vehicle at the intersection that had had a stop sign there for more than 25 years. She even told the officer on site that she had stopped at the stop sign. If that were the case, we would not be in this position. He would still be alive. He didn't get a chance to say his final goodbyes to his family or to anyone. Of course, why would he? He wasn't sick, so why should he have said goodbye? How was he to know that some selfish, disrespectful person that day would take his and our world away from us? I wasn't ready to say my final goodbye. Your Honor, I stand before you to ask you to take away Ms. Regina Pilaski's freedom from her for as long as possible. I ask that you never allow her to possess a license again on any day in her life. I also would like to point out that not once during the entire time of court have I seen Ms. Pilaski have any remorse or show any kind of emotion in what she has done to me and my family. Instead, I have seen her laughing and smiling. I hope that every time she has and will pass that intersection in Hayes Tower and Van Tile, she is reminded of what she did to him and his family. Most of all, I hope you remember October 18th, 2023 as your worst day of your life. Will I ever find it in my heart to forgive you? I cannot answer that at this time. I may in time, as the Lord has taught me to forgive, as my dad. Will I ever forget? Absolutely not. I will be at every parole hearing if she has one to remind the court and her of that as well. Your Honor, I know you nor anyone else can bring back my dad, but the next step to help us with healing would be give Ms. Pilaski the absolute max sentence that is allowed by the courts. Thank you.
Thank you. Ma'am, did you wish to give a statement as well?
Yes.
Can you state your name for the record?
Samantha Wonhoff,
Spell that.
WAHMHOFF.
Thank you. What is it that you would like to say?
On October 18th of 2023, I started my day like any other, getting ready to work and getting the kids up and ready for school. Had my morning conversations with my dad, John Sharp, and then said goodbye and headed to work. At 7:18, I'm receiving a text from my dad, and it read, Corbin lose his head if it wasn't attached to his body because he forgot his key again. I giggled to myself, and because I know my son always forgets things, I replied with the emoji of the hand facing on the forehead, and not knowing that that was going to be the last conversation I would have with my dad. I continued with my work as I was on the phone with insurance companies regarding patient medications when I saw my sister, Tina Kuko, calling me. I thought to myself, why is she calling me? She knows I'm at work. I shrugged it off, saying, oh, I would call her later. When I got off the phone, I looked at my coworkers with a smile on my face and inside in relief because I had finally gotten a prior authorization for the medication for a patient. Then one of my coworkers said that she had just received a text from her sister-in-law that there was a bad accident right in front of her house. I asked if anyone was hurt. She was not sure at the time. She then said the location of the accident was Hayes Tower and Van Tile. I did not hear what else was said next because I looked at the time and realized it was about the time for my dad to leave to go get my kids from school and pick up my daughter to take her to dance. Then in him, even my sister just called, and she never calls me at that time. I immediately grabbed my phone and called her back. She asked if I had heard from Dad. I said, not since this morning. Why? She said that Dad had been in a car car and they were bringing him to the ER. She said that one of her coworkers was going to bring her up to the ER and would meet me there. Without hesitation or any word to anyone, I took off running down to the ER. All I can think about was how long it felt to take me to get down here. I was so out of breath, it took me a minute to get out. My dad is John Sharp. He was just brought in. Where is he? One of the receptionists got up and a nurse came out and she asked her where John Sharp was at. She looked at me and told me to come with her. She told me to wait in a room. I know what that room is for, not because I work there, but because that is the room that they made us go in when my mom had passed away. I told her I didn't want to go in there. I know what that means. Where's my dad? After a few times telling me to sit down, unwillingly I did. A man came in and said that he was one of the EMS that was there. And then a police officer came in and asked if anyone else was coming, and I told them my sister should be here anytime. I asked to get where my dad was. They told me they tried everything they could, but they were not able to save him. It was like being punched in the gut. All I could do was cry. I told them they were lying. At that moment, it felt like my world had stopped. It couldn't have been true. There was no way he was gone. It felt like I had been sitting there for hours before anyone came. But I know it wasn't that long before. My sister came in and I had to hear it all over again. We tried everything, but we couldn't save him. The words just kept ringing in my head. I know I had to call my oldest, but I didn't know how I was going to tell him. There was no way it was going to be easy. I told him Papa had been in a car crash. He was gone. You must come to the ER. The sound and gut-wrenching feeling I had telling him and hearing him cry just killed me. I could hear him tell his grandma that she had to bring him to the ER. He said he was on his way. I know the EMS medic and the police officer were saying something to my sister. But all I could hear was mumbling. My sister's husband Mike came in, and my son Isaac. As we were being told what happened, all I could think about was how alone I felt. How was I going to tell my other 3 kids what happened? Would they understand? How are they going to take it? Am I going to be strong enough to help them through this? What was going to happen to us? How am I going to support them and take care of things without my dad? My dad had done so much for me, getting the kids to school and sports, appointments, anything. I was unable to do just so I could work. I then looked at Isaac. I could see and feel the sadness and anger he was having. I knew I had to figure this out and find a way to be strong for him and his brothers and sister. My niece and her boyfriend came in, and it started all over again. After a few minutes, we were told we could go back to see him. There was no way I could go see my dad. I didn't want to have that image in my head. I had too many other visions going on in my mind, and I did not want that too. My sister knew I wouldn't go in. I couldn't go in to see my mom when she had passed either. I also knew I had to go back to the office and let them know what was going on, and I had to get my other kids. I told Tina I would meet her back in the ER consult room after I get things figured out with the kids. Walking back to the office, it took all I had not to cry anymore and gain my composure. As I walked in the back office door, a few co-workers that were in the area looked up and seen me. I looked one of them in the eye, and something told me she already knew what was going on. But I wasn't sure. All I could get out was Dad is gone. Dropping to the ground crying, one of the providers told me to go into her office. I knew she didn't want me like that in front of patient area. Sitting in her office crying, I was telling them Dad was hit by a car and killed on his back. But I am not sure if they could understand anything I was saying. I kept asking them how I was going to tell the kids that their papa was gone and not coming home again. Then I remembered I still had to go get them from school. They told me I couldn't drive and that someone would go get them. They said they wouldn't be looking for anyone but Papa. because they knew that Papa was coming. If they seen my car, they would go. And I didn't know they would go with anyone else. Kiara had dance and Corbin had football practice, and I didn't want Connor to be home alone. They told me it would be okay that they could take the kids to their house until I had gotten home. I was concerned about Corbin missing practice because that weekend was his last game. And if he wasn't there at practice, he wouldn't be able to play. As soon as I said that, one of the girls got on the phone and called his coach. Our boys were on the same team. She had his number in her phone. He said it would be okay if he missed and that he would not hold it against him. He could still play in the last game. My coworker said it would all be okay. One of them would get them. He told me to go back to my family. After I composed myself a little bit, I thanked them all and went back to the ER with my family. Sitting there talking with my niece, she told me she's seen bruises on his body. Was to be expected. But what got me was that she said his hands were so cold. I know that happens, but it just made it feel even more real that there was no life left and he was gone. And my family had been told Dad wasn't wearing his seatbelt and that he was ejected. I looked up at them knowing that was a lie because my dad never drove without his seatbelt. He wouldn't even move the car until everyone in the car had their seatbelt on. Isaac and Mike said they looked at the guy and said, bullshit. He never drives without his seatbelt. At that point, we were all upset that they were giving us false information. I did ask if anyone had told them about the other person, if they were okay or not. All that was told to us was that they were alive with some injuries. There was a part of me that was relieved they were okay, but then the other part of me was not, because they were still here and my dad wasn't. At that time, we did not know the whole story as to what happened. I know my dad is not perfect, but I always know that my dad was a very cautious driver. He always said, you can't always trust the other drivers, so you have to always stay alert. After a little while, we had all decided that there was nothing else that we could do there and to go back to our homes, to our kids. The drive home felt longer than usual. As I got closer to the crash site, I could see what happened without actually seeing it. And my heart started pounding harder. And I had to fight back the tears so I could get home. When I pulled in the drive and opened the garage, I was hoping this was all a bad dream. And I would see my dad's truck inside. But I didn't. I had to tell myself, it's Wednesday. Dad is just out at the range like he always is on a Wednesday. home later. I called my friend to let her know Isaac and I were home. As we were sitting waiting for the kids, he told me this was his fault. I asked why he thought it was his fault. He said Papa was supposed to get him that morning so he could go to the range with him. I told him I was really tired from working late and I needed some more sleep. And I asked him to get me this afternoon. Papa said he would get me before he got the kids from school. If he would have got me this morning, he wouldn't have been out at that time. I told him it was not his fault. It was the other driver's fault. Besides, if you had been in the car with him, I could have lost you too. He said maybe it should have been me instead. Those words made my heart stop for a few seconds, and I told him not to think that way. It should not have been him or Papa. I know to this day he still blames himself. When the kids walked through the door, I could hear them laughing, and I knew they had a good time at my friend's house. I stood there taking it all in for a second because I knew it would all end after I told them what happened to Papa. After a little while, Corbin knew there was something wrong and had asked me what was going on. As the knots in my stomach got tighter and the tears started coming, I told him Papa was in a car crash and he didn't make it. I wasn't sure if Kiara understood what I was saying, so I looked at her and said, Papa will no longer be coming home because he's not with us anymore. Isaac and I told them that we all needed to be there for each other and we would get through this together. Corbin then said, this is all my fault. I forgot my key to my locker and I asked him if he could bring it to me. As he was probably bringing it to me, I told him it was not his fault. We didn't even know what Papa was doing. He could have been going to the store or something. Corbin said maybe, but he still had to bring me my key. In my mind, I knew the time of the day, and he was probably on his way to drop the key off before picking the other kids up from school. I couldn't tell him that because he was already blaming himself. At that moment, I started putting the blame on me. If Dad wasn't helping me to take the kids to where they needed to be so I could work, he would still be here. And I realized this was not Isaac, Corbin, or my fault. The person responsible is the other driver. That night I cried myself to sleep and woke up so many times screaming and crying and just feeling Isaac had come in to calm me down. I felt horrible that he had to do that. I was mother. I should be the one to be strong and protect him, not the other way around. He told me we are here for each other. The next morning, I went to the kitchen. thinking I was going to see Dad at the table, drinking his coffee and playing his board games on his phone. But he wasn't there. Knowing I will never get to hear his voice again and hear his laugh, enjoy our conversations, even our disagreements. I tried to convince myself that Dad was just out and would be home anytime. The emptiness and depression were eating me up inside and consuming me until I felt numb. Then I started thinking about all the things I had to figure out. How was I going to get the kids from school every day, their activities? How was I going to pay all the bills? I had to make calls and put everything in my name. Things started to become overwhelming, and so much that I had to stop thinking about all of it. So I focused on one thing, how I was going to change my schedule to get the kids to and from school. When I returned to work, my boss and I worked out a plan so I could come in later and leave earlier. Some days I had to come back to work after bringing the kids home just so that I could make the hours for the week. I needed as much as I could so that I could make ends meet. The next day we were given more information about the crash and pictures. The more information received, the pain, sadness, and anger rose. A coworker had reached out to me to let me know that she did not witness the crash, but she was definitely right there right after it happened. After she'd seen the photos and knew how cautious my dad was, there was no way that he was ejected, but I had to hear it. She told me her and a few others seen his truck and called for him. He was unresponsive and there was no movement. She said that he was definitely not ejected. Once the police report and the investigations were done, we were able to read it. After we had gotten through it, we were told if we had any questions to write them down and give them to the prosecuting attorney so that they could be addressed. My sister wanted to go over it as a family, so that's what we did. As we read through all 84 pages, the visions of how it happened became more vivid in my mind. Not only did Miss Pilaski not stop at a stop sign that had been there for years, so it was nothing new. She was also speeding, never even tried to stop until the last second before hitting my dad. She was also on her phone, not hands-free, mind you. The blood test that she agreed to came back positive for drugs that she was never been prescribed. Due to Ms. Pilaski's negligence, my dad would no longer be able to be with his brothers, his sister, 2 daughters, 8 grandkids, and other family members and friends. Be around for holidays, birthdays, weddings, meeting his great-grandchildren. This all brought up so much anger that it's not fair. Christmas of 2023 was the worst I have ever had. Not only were my kids gone that year with their dad, I no longer had my dad. I was all alone. Even when the kids were gone, my dad and I would have our own little Christmas and make dinner together. There was nothing special about that holiday. Just another day not trying to lose my dad consumed me. The thought of the woman that killed my dad was still able to enjoy her family and be free to do whatever she wanted put a bad taste in my mouth. I had to tell myself everything would be okay, and soon she would be prosecuted for what she had done. I know it won't bring my dad back, but he deserves justice, and so does my family. And we need closure. I don't know how much closure it will really be that it will bring me, as I am reminded every day what happened on October 18th, as I drive by the crash site daily, going to and from town every day. I am forever reminded he's never coming back. Not only did Miss Pilaski take a brother, a father, a papa, uncle, etc., but she took away from him. But not only did she not take life away because of what she did, coping with all the changes my kids and I have to make has taken a toll on my mental health. I have had to seek mental health and was put on medications, but I still don't feel myself. My son Isaac has sought medical help as well. This has been going on for a year and 6 months and 22 court dates. During every court date, I have had to relive every detail of that day. I have never been able to fully grieve because of the ongoing case. I feel that some of this court dates were unnecessary, as it was the same thing that had been said already. One court date was rescheduled due to Ms. Pilaski's lawyer being gone out of town. Come to find out, it was also during the same time that Ms. Pilaski was going on a family vacation to Alaska. To be honest, I find that to be very convenient. I also don't understand how she was allowed to go to Alaska in the first place. We were told that this trip had been planned for over a year, and because she is not a flight risk, the court allowed her to go. None of that should have mattered. The fact that she killed someone should have been enough to not allow her to go. My dad had plans too, but he will never be able to do any of his plans he had. I understand that court cases take time, and this is not the only case going on, but I feel that this has gone on too far. At the last court date, my sister and I found out just before court that Ms. Pilaski was going to plead guilty and there was not going to be a trial. This came as a shock, as we didn't really know what to think. I can only speak for myself, but I think my sister and the rest of my family would agree that we want this all to be over, Ms. Pilaski to pay for her crime at the highest sentence.
Thank you for your statements. Mr. Rolla, anything that you would like to state for allocation on behalf?
Thank the court for allowing Ms. Sharp's daughters to speak. Hopefully it will give them some sense of being able to tell the court how to do it. Since the case, this is a tragedy on multiple levels. Some of those you've already heard from the daughters. And although there are circumstances, as this court's very well aware, that can occur despite our best efforts to avoid them, this was not such a case. The death of Mr. Sharp was completely avoidable. The defendant should not have been speeding. The defendant should not have been speaking to her daughter on the phone. She should not have been going through a stop sign into an intersection where she's required to stop, and she did not have the right of way. Counsel for the defense yesterday at April 28th at 10:52 a.m., almost exactly 24 hours before this hearing, minus 8 minutes, sent to our office a memorandum of sentencing. Now, I understand they can do that. I also understand the court normally has a 72-hour rule in regards to that situation. So in that regard, people object to the timeliness, or in this case, untimeliness of that. However, of greater importance to this court sentencing the defendant, and quite frankly, the far more concerned of people is the claim that the defendant in that very statement, quote, wishes to express nothing to the victim's family other than sympathy and compassion for their loss and hope that they find peace, end of quote. However, then, continues in the statement, the next thing they do is try to blame or put blame on the victim by stating the decedent's truck did not come to a complete stop. This is a situation where the defendant's going 60 and a 55 while talking on a phone, blowing through a stop sign at 60 miles per hour, and doesn't have any braking until what? 0.2 of a second before impact. Further, they describe under the heading lack of scienter. Defendant claims, quote, she did not operate her vehicle in a reckless manner. To this, the people state factually and legally, we strongly disagree. Blowing through a stop sign at 60 miles per hour into an intersection while talking on the phone is an example of willful and wanton directly endangering the safety or property of others. The very exact legal definition of reckless driving is set forth under Michigan compiled laws 15.14. In addition to the fact that this is an offense the defendant has already entered a plea to before in this court. So to say she wasn't driving or to in any way infer that she wasn't driving recklessly, quite frankly, is an insult, not just to the court, but to the victim's families. Then, continuing on, there's the request to impose no jail time or another request to simply have house arrest. It's the people's opinion that the defendant, by requesting these particular matters, is still refusing to take responsibility for killing Mr. Sharp. And a request is quite frankly not only an insult to the victim's family members, but is contrary to the defendant's prior claims of empathy or compassion to them. Now, the people simply cannot understand what part of the fact that she killed someone does not seem she's unable to grasp. And her refusal to do so, quite frankly, reflects on this court's ability to have her follow any terms of probation enforced by this court. The only thing you can have her follow, perhaps, is incarceration. Thank you, Your Honor.
All right. I do want to clear up the factual issue here because it was referred to by the victims in their statements, and I read it in their statements prior to that. And then there was documentation submitted that seems to suggest otherwise. So there's this question of whether or not Ms. Pilaski had taken morphine or was under the influence of morphine at the time of the accident occurred. I know the victims made statements indicating that she was under the influence. The documentation that I saw indicated that that was morphine that was administered at the hospital after, and then it showed up in later blood tests. And I think the record needs to be clear about whether the prosecution's position is that she was under the influence equivalent to morphine at the time of the accident or whether that was administered at the hospital later. So Mr. Rowland, can you address that?
And Judge, that's why I didn't mention that in my elocution. I can't say definitively one way or the other. There was the dispute, I guess, and the confusion as addressed by the victims is based upon the fact of the timeliness as to when the blood was drawn, and then later when supposedly the defendant received morphine at the hospital. I can't definitively say. We didn't charge her with it being under the influence of morphine. There was an original charge that way, but whether or not that was the case, I can't say because I don't know the timeliness of those two episodes. I know she got morphine at the hospital. What I don't know is whether or not she got that before or after blood was drawn for the tests that were done. So
you're not taking a position one way or the other.
I'm not, Judge. That's specifically why, that's why I did not address it in my elocution. Thank you.
All right, thank you. Mr. Steffi, if you and your client would like to come up to the podium.
Can I address that issue first?
Yes.
Is that okay? We submitted medical records as well as a forensic nurse's review of those records. It's clear at the hospital, Ms. Pilaski was given a urine drug screen at 1:18 p.m. that was negative for opiates. Morphine 4 milligrams was administered by the registered nurse at 1:47 p.m. The Michigan State Police toxicology blood draw, was taken at 14:01, which is almost 20 minutes after receiving morphine. Which was prescribed obviously in the hospital. I gave some of these records to the MDOC agent. They reviewed them. They determined that there was no crime as the scoring indicates. So I just want that to be objectively clear for the records. The morphine was given by the hospital before the blood draw.
All right, thank you. And if you and your client would like to come up to the podium and do you have further allocutions or stuff?
Thank you. Judge, I appreciate you taking the time to read the large volume of mitigation materials that have been submitted by me and my clients, as well as my sentencing memorandum, which I explained somewhat the reason for the late filing. I appreciate your understanding of that. The first thing we do want to say, me, Mr. John Steffi, and Regina Pilaski, is that we're sorry. We're very sorry for your loss. You lost a good man. And I know Your Honor understands, perhaps others don't, that a criminal defendant cannot say, I'm sorry, when there's a pending civil suit and a pending criminal case. I can assure you that Ms. Pilaski wanted to reach out. She asked me about it. There was a no contact order with the family of the deceased as well. So there's many reasons why she couldn't do that. Ms. Pilaski is exactly the type of person who would jump up and say apology right away. I understand the confusion about the legal system, but she's been sorry every day since that accident, and she continues to be sorry right now in front of Your Honor. And I can understand the feelings from the bereaved. I myself lost a parent to a motor vehicle accident. It is painful. I do empathize with you. In the facts of this case, Judge, there is not a criminal intent. We pled to, and we're not contesting what we pled to. In my sentencing memorandum, I was really suggesting that it could have been viewed as careless, as referred to negotiations that occurred before the plea was accepted and entered. So I'm not disputing the plea, which is to a willful and wanton disregard for the safety and property around Ms. Pilaski while she's driving. She, however, did not have any criminal intent to hurt anyone, hurt anything. This was a mistake. This was an accident. This is something that, but for the resulting tragedy, would be a civil infraction or a misdemeanor. And as long as I've been practicing in this jurisdiction, I have been a bit baffled how the legislature has determined that reckless driving without consequence is only a 93-day misdemeanor. But when there's injury or death, it becomes a serious, highly scorable felony. but that's the state of the law, and I accept that. I'm glad that the PSI acknowledges that no crime occurred, being the OWI allegation in this case. The records objectively prove that. And I'm disappointed that the victim's family was not made aware of that. That was mentioned 6 or 7 times in their statements, and I understand why it would be. But Ms. Pilaski did not take any opiates or any illegal or unprescribed medication before this accident. Then regarding the phone use at the time of the accident, she was on the phone with her daughter, but it was on a Bluetooth device. There's been no evidence presented otherwise in this case. So I feel like that's an improper conclusion based on the evidence. So there's certainly no accompanying citation for using a phone with your hands, which is of course illegal now in our state. So Ms. Pilaski is 56. She's here before your honor on her first criminal conviction of any kind. As far as I know, she doesn't even have a driving abstract to talk about. She has lived her entire life in a rather exemplary fashion. And then she made a really bad mistake. It was a mistake. Our case law statutes direct a sentencing court to examine the background of the defendant as much as the nature of the offense. Frankly, in a different world, I think the victim and Ms. Pilaski would have been friends. They're very similar. Ms. Pilaski is a matriarchal figure in her family. She's a grandmother, mother, wife, a surrogate mother to neighborhood kids. She takes in animals. I've described, and your honor has read a lot of letters. Regina volunteers all the time. She volunteers with the 4-H organization or club, the local equestrian community, the Otsego County Fair. She volunteers to transport equestrian competitors and their animals to competitions. Several of the letters we submitted specifically vouch for her safe driving and that they would trust her to drive their family or animal around, which further reinforces that this was an honest mistake. She has accepted responsibility and she has now a felony record, which is, as your honor knows, quite the consequence in and of itself going forward. Frankly, as your honor can note, there's a lot of people here supporting her in person today as well. I do not believe, to my recollection, that I've had a client with more support from her community and family, which she has here in Gaylord and the bigger Otsego County area. As outlined in my memorandum, our statutes dictate, in this case, because the guidelines are 0 to 17 months, that an intermediate sanction be imposed, and that shall be imposed for the statute. And I'm asking your honor to do that. I'm asking your honor to impose probation, not jail. In this case, jail is certainly not a deterrent, does not accomplish one of the sentencing goals of deterrence. Obviously, it can be used as punishment, but there's nothing to deter about her behavior or her conduct or her personality or character. Each day, and I've been working with Regina for quite a while now, this case has been pending. She is so sorry every time I speak to her, every time I interact with her. She is literally shaking standing next to me. She was shaking listening to the heartfelt testimony from the victim's family. Her remorse is 100% genuine. She, as a result of the accident, sustained physical injuries. She's under the treatment of several healthcare providers, as I've made the court aware of, for physical injuries and consequence and mental consequences. She has multiple providers, multiple appointments, needs the use of therapy animals. She pays for this every day, and she will for the rest of her life. She prays every day at her house. She actually has a prayer candle that's been set up since the accident. Every day she prays to that. She's a very religious woman. Her pastor spoke highly of her in his letter. Obviously, the court has immense power over people, but she will continue to be punished by a different agency, whether that's God, fate, or psychology. So every day she lives with this tragedy. Your Honor, to confine your analysis of the previous testimony to the relevant portions. And I know Your Honor is familiar with why a defendant cannot say sorry during a criminal case or a civil case. So I just wanted to say that on the record. Again, I'm disappointed, frankly, that the victim's family was not made aware of the chronology of the blood test at the hospital, and was not made aware that the morphine was given to her by the hospital, and then law enforcement requested her blood test after that. And I think it has greatly colored their experience and view of Regina here in court. This kind of case is really hard because it doesn't involve an intention to hurt someone, but involves a death, and every death is tragic and has a consequence that ripples throughout a family and community. But punishing someone by incarcerating them will not serve the goals of the community for the best interests of the parties here today. As I've said, I've been on both sides of the situation, and I know that personally. Ms. Pilaski has touched the lives of so many people throughout her life and will continue to do so. I really don't believe this one mistake should cause her to be incarcerated by the court in this county. The Pilaski family has dealt with many tragedies over their history. They lost their home to a fire. Her husband Daryl was shot in the face with a gun downstate, and their son was involved in a horrific motor vehicle accident himself and was injured. Long-lasting, life-changing consequences happened. This is a tragedy for everyone, as Mr. Rolla said, and I know it's one that Regina and her family will ultimately overcome. I asked that the court sends her to probation, so her treatment for her medical and mental health needs can be monitored. As per my memorandum, I do request a deferral, I'm sorry, not deferral, a delay of sentence under 771.1, which this court is able to do. If that is done, Ms. Pilaski could be placed on probation for up to a year. During that year, she will show to your honor that she deserves leniency and deserves to not go to jail. In the alternative, I ask that if jail is imposed, that community service in lieu of jail is part of that sentence. I have also been in contact with the house arrest company that can arrange for her to be equipped with their equipment out of Representative Sheboygan, and that can happen quite quickly. So I would further ask for that if that's the direction the court goes. I'm going to ask your honor if one witness you don't have a letter from could read a letter that was presented to me this morning before Ms. Pilaski speaks.
It's generally my practice that I don't allow folks on the side of the defendant to speak. I do, obviously allow letters in support, and I have read the many letters that were submitted.
Thank you. I just wanted to request that. So, your honor,
it's not anything special in this case. It's my general practice.
Yes, thank you. So your honor, you know my request, and now it's time for Regina to tell you how she feels.
Ms. Pilaski.
Your honor, my name is Regina Pilaski. I am writing you this letter to you and to the Sharp family. My deepest apologies. My heart is crushed. I'm grieving along with you, them. And they're not, and there's not a day I do not pray for your family, their family, the Sharp family. I've had a blessed candle burning constantly since that awful day when I got home from the hospital. I do not have words to express to you or to them how I feel. I'm just sick over it. I wish I had never been in the vehicle that day. It was a tragic accident. I would have never wanted to hurt anyone. And I haven't driven since. It frightens me to ride in a vehicle. My doctors, to my doctor's appointments, therapies.
We need to stop you doing it, right?
I think maybe that might be helpful.
All right, let's take about a 5-minute break here and we'll come back.
All rise.
back on the record. Pilaski, you can continue, please.
Thank you, Judge.
I wish I had never been in the vehicle that day. It was a tragic accident. I would never want to hurt anyone and haven't driven since. If I didn't ride in a vehicle for my doctors and therapy appointments or to the grocery store or any other time. This accident has left me with not only physical problems or mental problems too. As I tried to deal with this every single day, if there was any day in my life that I could take back, it would be October 18th, 2023. Is this tragic accident I will carry for the rest of my life? Your Honor, it's really. This is my family's story. I wish I would have died that day instead of Mr. Sharp. I'm not suicidal, but my heart is so broken. I don't have words to express how I feel every day. I punish myself and I will for the rest of my life. My deepest condolences to the Sharp family. And Your Honor, I am so sorry. Yeah, that's it. That's it in my statement, sir.
This is a case that I've spent a lot of time considering, thinking about. As I indicated, there were lots of materials to go through. Took a lot of time in reading all of those letters on both sides. I'm glad that I was able to receive all of that well in advance of the hearing today, because this is a really difficult case. I think that's a incredible understatement to decide what is a just and fair outcome here. And some cases are pretty clear cut in what a judge should do at sentencing. This is not one of those cases. And so I did spend a great deal of time considering both sides of this. And the victims, number one, the family that made statements today, very much appreciate the statements that you made here in court. They were extremely compelling. I think those statements, along with the written statements that I received from the victim's family, very poignantly express the pain, the grief, the loss, and the difficulty that family has had going through this. And the type of person that Mr. Sharp was, who by all accounts lived a very exemplary life and certainly deserved better than this at the end of that. And so I very much appreciate all those statements, because I think they did very well express what that family's gone through as a result of this. I also appreciate the many letters and the amount of support that you've received, Ms. Pilaski, from friends and family and community members. Similar to Mr. Sharp, by all of those accounts, it appears you led an exemplary life as well. And I think it's unlikely that such an outgoing support from so many different areas of the community would occur if you were generally the type of person who engaged in wrongful conduct or was hurtful to other people. And so I think the difficulty in finding a just result in this case comes from the fact that there are very valid competing sides to both of this. Again, from the victim side, there's no question that you caused this accident, Ms. Pilaski. There's no question that you caused the death of Mr. Sharp, and that it was the result of poor driving, of speeding, of not giving due attention to what you were doing on the road. I'm sure the phone call played a part in that. I'm sure the speeding played a part in that. I'm satisfied based on the documentary evidence that I've seen and the lack of the prosecution taking a stance one way or the other on it, that you were not under the influence of morphine at the time that this occurred. I'm satisfied that this accident occurred as a result of distraction, inattention, a failure on your part to take due care as you were operating your vehicle on that day. Again, and by speeding, by being on your phone, by being distracted. And that while you may not be generally a careless or reckless person, I think you certainly were during the course of this incident, and that resulted in the most serious consequence that can result from inattention and recklessness, and that's the death of another person. So I think there's a valid argument that the victims make that there should be some degree of punishment for you because of your actions and because of the results of those actions. I think there's also a valid argument to be made on your behalf that Mr. Steffi has put forward, which is you're a 55-year-old woman. There's no prior criminal history, no prior negative history by all accounts. Been a productive member of this community and done much more good over the time of your life than you have caused harm. And so that's what both sides are saying in this case. And I have to take both of those sides into account, and I have to look at what does the law say? What is the law? What kind of guidance can I get from that in terms of what is an appropriate and a fair and just result here? And as Mr. Steffi indicated, and Mr. Rolla as well, that court has to fashion a sentence that's reasonable. That sentence has to be proportionate, both to the offense, in other words, to the seriousness of the conduct and what occurred in that particular case. It has to be proportionate to you individually in your individual circumstances, Ms. Pilaski, your past record, past history, and so forth. And a sentence that's within the guidelines is presumed to be a reasonable sentence, and a proportionate sentence in this case, the guidelines are 0 to 17 months. Court also has to look at statutes. In this case, as our legislature, our society through our legislature determined under statute that in cases like this which call for an intermediate sanction, that the court should look first to other types of punishments as opposed to jail, and that jail is not an automatic. And then finally, the court has to address 4 different factors to try to do that through sentencing, and that is punishment, provide a consequence to you for your wrongful conduct, protection of society, so that the community isn't further put in danger, rehabilitation, and deterrence, a sentence that will prevent other people from engaging in the same type of conduct. And so looking at all of those things, the court has a number of different mechanisms that I can use to try to accomplish those goals and to arrive at a proportionate sentence. Of course, incarceration, taking away someone's freedom for a period of time, through jail or prison. There's probation, which allows for drug and alcohol testing, supervision, community service, counseling, substance abuse treatment. There restricts an individual's ability to go where they want to go, do what they want to do. and who they can associate with, and it provides a degree of accountability so that there's supervision of that individual, and that if that individual engages in further wrongful conduct, they can be held accountable by being brought back to court and further punished. Of course, there's monetary fines and so forth as well as punishment. In this case, I think a combination of these things is appropriate, and I think will address all of those goals of sentencing and result in what I find to be an appropriate and proportionate sentence. I do think there needs to be an element of punishment here. Clearly, again, was your wrongful conduct, whether it was intentional, whether there was an intent to harm or not, it was wrongful conduct here that resulted in the most serious consequence that can result, and that's the death of another person. I think that also has to be balanced by the fact that this is not typically your behavior, Ms. Pilaski, and not something that you're typically doing. So there has to be a balancing. Again, the guidelines are 0 to 17 months. The court finds that a sentence of 6 months in the Otsego County Jail accomplishes the goal of punishment, but also recognizes the mitigating factors. I also don't have an objection to your participation in the work camp program and your immediate participation in the work camp program. I think that's appropriate under the circumstances here. It is the type of thing that the court would typically order in this type of crime. I also think that probation, although it wasn't recommended, is appropriate. For all those reasons I've stated, it provides a degree of oversight, provides a degree of assurance to me and to the community that you are going to be monitored for a period of time to ensure that you aren't further engaging in dangerous or reckless behavior that could result in injury to another person. Provides a degree of accountability to you as well. So the court is going to order probation of 24 months, where it's going to adopt all the standard terms and conditions for that probation. So to sum up, again, the court is going to sentence you to 6 months in the Otsego County Jail. You do have credit for 1 day served. The court has no objection to your participation in the work camp program. The court is going to order 24 months of probation, subject to all standard terms and conditions of that probation. Court is going to order a crime victims assessment in the amount of $130, court costs of $325, a DNA testing fee of $60, and a $68 state cost. You do have the ability to seek an appeal of the sentence. Mr. Steffi, provide your client with an acknowledgement.
Your Honor, would it be possible for Ms. Pilaski to surrender herself to the jail on Friday morning with all of the medication she needs to take as noted her health is quite fragile?
Again, that's my practice is to not allow that, and my experience that things don't go well and the court allows people to report later, so we can certainly bring this to get what she needs at this time. But she does need to report to jail at this time.
Tuesday.
The record, Mr. Steffi, the appellate has been acknowledged.
Yes, correct. And acknowledged and signed.
We're gonna go right over that here.
That concludes the